Hi team, Brent Norling from Norling Law here. For those of you who don't know us, we're a specialist litigation practice based in Auckland, North Shore. We have a core focus on commercial disputes and in particular insolvency law and insolvency related issues. Today I thought I'd do a quick video on shareholder disputes and shareholder structures and some common pitfalls that we see that often result in disputes. Now, a bit of background, the Ministry of Business Innovation have given us some statistics that suggest 66% of businesses fail. Now, that may not necessarily be an accurate statistics because it's a little bit problematic. It also includes all the entities that are struck off the register and they're completely voluntary, and there's a variety of reasons that could happen, but it is very true that a lot of New Zealand businesses do fail, especially small businesses. Now, with that in mind, what we see is a lot of business owners going into business with other business owners without appropriate shareholder agreements put in place. Now, this can be a very big problem. One pattern that we see is when people are in the trenches and they're working hard and they're building a business, there's not a lot of money. Generally, the relationship is very, very good. People are committed to the common goal, and often when there's money, there's been success, that's where we see a lot of disputes. Now, for example, one person could be doing more work than the other, one could be getting in more clients than the other, one manages more staff than the other. There is a variety of reasons why somebody may say, I do more than you and therefore I deserve more, whereas on the outset there might have been an expectation of 50-50. Now, these flow from a very powerful human emotion, and it is greed, or it is a perception of fairness, and it can drive people into corners. Now, a very well structured shareholder agreement that's fit for a particular purpose can often avoid all of this drama, and it really does need to be custom. I see a lot of problems with template agreements that are not fit for the particular people, and so I would recommend investing in an appropriate agreement that is properly being discussed between the parties. And there's a variety of things that you may want to consider when you're drafting one of these agreements. For example, who has the power to appoint and remove directors? Is it the standard 51% vote of shareholders, or does each shareholder have a right to appoint their own director? There's so many ways you can deal with that issue, but it is important that the parties make it clear how the company can be directed and how directors can be removed. The other thing is the shareholders, often you'll have minority shareholding. Now, how are they to be protected, or should they be protected at all? Should certain resolutions be unanimous for all shareholders, or are we going to stick to 51%, 75% majorities? These things should be ironed out at the outset. Another big problem is a lack of any real exit strategy. So what if you've had enough? What if you want to leave? Are you free to sell your shares to anybody at any time? Or can you only sell to the existing shareholders under an agreed mechanism, and which includes to value those shares? And unfortunately, people die. So what happens when you die? Do your shares succeed to your next of kin, to your children, to your wife? And is your business partner going to be okay with that? Often the answer is no, because these people want to take a company on a different direction. Often they don't have the same passion that the original shareholder had. So is there a mechanism in place that requires a mandatory buyout on death? And if so, for what price? Is there an agreed value or a process? And so these are very hard conversations that need to be dealt with up front. Capital raising. How's capital raising? How's that to occur? Does each shareholder contribute equally? Is there a process in place? Is there limits in place? These are all important, and Same with a business plan. Should your business plan form part of your shareholding agreement? And if it does, should that be a living document that's reviewed annually? Because often things evolve, and so will the business, and so we shouldn't be locked into an agreement that was entered into in the honeymoon period in the startup stage. But it is important to have very clear agreement on that business plan. Another very important area is restraints of trade. So can you compete with your business you have shares in? Most people would say no. What about when you leave and you sell? Is there a mandatory period that you can't compete for 12 months, 24 months, 3 years, but whatever it is that important to you, and should it be agreed now before it's too late? And I would suggest that you do deal with that up front. Now, getting into the real serious stuff where people really don't like to discuss, and that is the dispute resolution clause. Now, templated agreements will often have mediation or arbitration, and it's not given any further thought. It's just there, and people avoid the discussion. Now, mediation, arbitration, great in some cases, not great in all cases. Some cases might want to go to a specific third-party expert in an industry that might be able to help resolve issues. There could be a process where the parties attempt to negotiate themselves by issuing formal notices, or perhaps we're just going straight to the High Court. Now, going straight to the High Court is never a great option, but there is a need for people to discuss their preferred dispute resolution strategy up front, and to make sure it's fit for the company and the particular shareholders. Things to consider are: do we agree on a methodology to value the business if there is a dispute? Do we agree who gets the right to purchase the shares preemptively? There is a variety of options. They should be discussed up front and agreed, because ultimately, if you don't, and there is a dispute, there's a fundamental breakdown in the relationship. The only real option is, if you can't agree, is to go to the High Court. Both parties are going to be engaging a lawyer, and they're both going to be engaging an expert accountant to value the business. So they're going to have two professionals in each corner. It gets very, very expensive very, very quickly, and should be avoided where possible. Now, if any of you have any questions resulting from this, happy to talk, and if you have any comments, happy to talk. Leave some questions down below, and you'll be hearing from me. Cheers.